Judge needs to address you, sir. Is that a problem, sir?
Yeah. You're a defendant. Sit at the defendant's chair.
I'm not a defendant. I'm sorry, officer.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen. And
no, I object. I'm not a sovereign citizen.
All right, sir.
The difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has...
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on a record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, so there's a microphone.
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the...
I didn't swear an oath to the Constitution.
You haven't...
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
All right, guys, buckle up because this hearing goes off the rails fast. The defendant tries to posture from the jump, refusing to follow basic courtroom direction. The judge shuts it down immediately, making it clear who controls the room and what happens next. This is the tone setter. No patience for games, no tolerance for delays. The warning is simple and public. Sit down, comply, or face consequences. From this moment on, the power dynamic is locked in, and everything that follows builds from this clash.
So you are upholding your oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay? Now I have...
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today. No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for...
The tension spikes as the judge escalates from instruction to enforcement. What started as resistance turns into a direct challenge, and the judge answers it without hesitation. This moment matters because it shows the court drawing a hard line. The defendant keeps pushing for control, but the judge reasserts authority in unmistakable terms. It is no longer about legal arguments. It is about order. The courtroom understands that the rules are not negotiable here.
So, with that being said...
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today...
You have a jurisdictional argument you want to make?
Well, I've served notice...
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a...
Yes or no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it today.
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan,
Is that,
I work
criminal
under the authority
or-
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law, so I'll need to know.
This is not admiralty,
What is
and
it?
it's not common law.
Which
It's
one is-
statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it? For the
My
record, I need to
jurisdiction is
have-
both civil-
I can't defend myself unless I have.
Now the familiar sovereign-style jurisdiction argument enters the room. The defendant attempts to derail the case by reframing reality itself, hoping confusion will create leverage. Instead, the judge listens just long enough to identify the flaw and then cuts through it. This exchange exposes the strategy for what it is: delay through wordplay. The judge does not mock or entertain it. He corrects it clearly and moves forward.
the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record,
there
right?
must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file. You want to see it?
Affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the state?
Sir, sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
Here the judge dismantles the argument piece by piece, explaining criminal jurisdiction in plain terms. This is not theatrics. It is instruction on the record. The defendant keeps fishing for loopholes, but the court anchors the discussion in statute and procedure. The moment is powerful because it removes ambiguity. There is no admiralty, no fantasy framework, just a criminal case under state authority. The path forward is now unavoidable.
I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. Because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
You're a witness. Say yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a
I
question.
object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611.
The defendant's refusal to stop talking turns into a direct consequence. The judge issues a contempt fine in real time, making the cost of disruption immediate and tangible. This is a pivotal shift. Warnings are over. Penalties are active. The courtroom sees that each interruption now carries weight. The judge is no longer negotiating behavior. He is correcting it, one ruling at a time, in front of everyone.
We'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on, have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
my objection is that I am here under the guise of
Bless
a
you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here it
This is the
says,
probable cause hearing.
it says, it's,
All right,
it
stop,
says,
stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing. Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the
I
evidence.
object that we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing, Mr.
It's still, on this.
Mr. Michaud, they're the same thing.
But it's still, I have.
Objections start flying without substance, and the judge demands what the law requires, a legal basis. None comes. This segment shows the difference between speaking and making a valid argument. The defendant talks, but the court listens only for relevance. When it does not appear, the judge moves on. This is procedure overpowering noise. The case does not stall just because someone refuses to understand how court actually works.
If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he can.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear? The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing.
The judge pauses the chaos to explain, clearly and carefully, the difference between a probable cause conference and a preliminary exam. This is a rare moment of clarity offered to someone determined not to receive it. The explanation is patient but firm. The court lays out exactly what today is and what it is not. The record becomes airtight. Confusion is no longer an excuse, only a choice.
Right now, do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this.
PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree.
Options are presented cleanly. proceed, waive, or resolve. The defendant avoids answering, trying to reopen side issues that have already been ruled on. The judge refuses to loop backward. This moment highlights how courts move forward despite resistance. Silence, deflection, and repetition do not stop the process. The law advances whether the defendant cooperates or not, and the pressure tightens.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so,
I'm not addressing any of that crap you
Can
got in
you-
front of you.
well, since you say you don't have a bond, can you express that via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
affidavit of fee schedule for violation of any of my rights?
There are no fee schedules.
Well, I gave you notice and.
Great. Then you gave me notice. Doesn't
The conversation drifts into bonds, affidavits, and private capacity claims. The judge rejects all of it outright. Not angrily, not emotionally, just decisively. None of it is recognized. None of it changes the case. This segment shows the limits of courtroom tolerance. Belief does not equal validity. The judge brings everything back to facts, identity, and responsibility under the law.
I can prove.
Okay, so.
Hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I.
You proved it for
threatening
me.
You threatening me.
But if you're not you, the threat means nothing.
You still threatening me and you're using it under color of law.
Okay, listen.
And plus
Listen
you
to
have,
me. Mr. Michaud,
you have
I've wasted too much time with you. Yes or
Okay.
no?
So.
Sir, don't argue with me. Yes or doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days.
The breaking point arrives. After repeated refusals to comply, the judge issues a contempt sentence. 30 days. Immediate. Final. The courtroom outcome is no longer theoretical. This is accountability in action. The defendant is removed, and the judge closes the loop with authority intact. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.